There's been some movement in the case challenging Illinois' gun and magazine ban that is sitting at the Seventh Circuit Court of Appeals. No, they haven't made a ruling yet. We're still waiting on that. But while we're waiting, you've got plaintiffs who have filed a notice saying, hey, court, take notice of this over here. And the states and the other defendants having to respond. Of course, we're talking about the case of the consolidated Barnett plaintiffs. You've got a variety of them from Southern Illinois and Northern Illinois challenging not just the state's magazine and gun ban, but also the Naperville, Cook County, and Chicago gun and magazine ban. So what's going on here is, let's take a look at the docket, where you have the most recent thing that we talked about was all the way back on July 10th, where they denied a amicus brief from John Cutinelli. But just a handful of days ago, Javier Herrera, who is the Chicago plaintiff, he filed a note about a measure that happened in a different court, and that was followed by Caleb Barnett and Hood Guns and More with the National Shooting Sports Foundation filing. But then you also had the state filing with Illinois State Police, Cook County, and others having to respond. What are they talking about here? Well, they're talking about this news story. Hawaii butterfly knife ban violates Second Amendment, court finds. So, of course, you may know this story just from last week when this ruling was made. And what you have is, at least when it comes to the Herrera plaintiff, essentially spelling out that they need to take note of this. So here's the note that was filed to court just a handful of days ago in the Seventh Circuit. Before they issued the ruling, the plaintiffs here want to make sure that they're aware of this ruling out of Hawaii, Tedder v. Lopez. And it says, first, Tedder rejects the connection that the purported dangerous and unusual nature of the regulated arms means they're not arms. The court reasoned that in Heller itself stated that the relevance of a weapon's dangerous and unusual character lies in the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Second, it goes on, it rejects the government's contention that commonality turns on whether the regulated arms are commonly used in self-defense encounters, and whether the weapon is commonly possessed by law-abiding citizens for lawful purposes. It also says, third, Tether rejects the government's contention that 19th century regulations of arms like Bowie knives are analogous to outright bans on possession. So that's just some of the highlights of what Javier is proposing there to make sure that the Seventh Circuit Court of Appeals sees. But you've also got this being filed by the Barnett plaintiffs, essentially going through the same thing, saying that Tether confirms that House Bill 5471 violates the Second Amendment, rejects the arguments, which Illinois repeats, that the purported dangerous and unusual nature of a bearable instrument the state seeks to outlaw means that they are not arms. And it goes on and gives more arguments. And of course, the state had to reply, so did Cook County, and they contend that that's not the case. So those are some of the latest movements. Of course, we'll be watching this closely. The latest being that you had Cook County and the state of Illinois having to file their response to the plaintiffs saying, hey, look over at that butterfly case from Hawaii that a judge said violates the Second Amendment. So obviously, that's the latest when it comes to the gun and magazine ban being in front of the Seventh Circuit Court of Appeals. When do they rule on this? There's no telling. But obviously, we'll be on top of it and let you know the latest. But those are the most recent filings as of yesterday.
From the Fly SPI Studios, take the easy way.